Welcome to the lecture on the civil court process. This lecture is part of the module on judicial process. The basic objective is to understand the civil court process. The important keywords in the lecture are the Code of Civil Procedure 1908, jurisdiction, suit, civil nature, plaintiff, defendant, pleadings, plaint, written statement, orders, rules, judgments, decree, and remedies. The civil process is provided for and governed by the Code of Civil Procedure 1908. The substantive provisions are contained in sections and the procedural provisions are contained as rules in orders in the first schedule. In summary, a civil proceeding takes place in the form of a suit between two parties known as the plaintiff and defendant before a civil court having jurisdiction. The suit is commenced upon the institution of a pleading known as a plaint by the plaintiff. In response, the defendant files a pleading known as a written statement. Based on the averments in both pleadings, the court frames issues which are adjudicated upon in the course of trial, following which the court pronounces its judgment and passes a decree or order. The object of this module is to explain the civil procedure by looking at the jurisdiction of civil courts, the steps involved in filing a suit, the various stages during the trial, as well as the remedies that can be sought for, and the procedures applicable after the court has pronounced its judgment. We will first look at the jurisdiction of civil courts. The jurisdiction of a civil court is decided on the basis of the case presented by the plaintiff in his plaint by looking at the substance of the matter and not the form. Every court has the inherent jurisdiction to decide whether the matter in which it is asked to exercise jurisdiction comes within its jurisdiction or not. Section 9 embodies a fundamental principle, ubi jus ubi remedium, that wherever there is a right, there is a remedy. It stipulates that a civil court has jurisdiction to try a suit if two conditions are fulfilled. 1. The suit must be of a civil nature, and 2. The cognizance of such a suit should not be expressly or impliedly barred. A suit is of civil nature if the principal question involved pertains to the determination and enforcement of a civil right which covers private rights and obligations of a citizen. A suit in which the principal question is of a civil nature does not cease to be so if the adjudication incidentally involves the determination of a question which is not of civil nature. A suit is expressly barred when it is barred by any statute for the time being in force. Since every presumption should be made in favor of the jurisdiction of a civil court, any such provision of exclusion of jurisdiction must be strictly construed. A suit is impliedly barred when it is barred by general principles of law, such as on the ground of public policy, or when a statute provides for a specific remedy. Consent can neither confer nor deprive jurisdiction. A decree passed without jurisdiction is a nullity, and its validity can be challenged at any stage of the proceedings, including in execution proceedings or collateral proceedings. Sections 15 to 20 regulate the forum for institution of suits. As regards pecuniary jurisdiction, Section 15 states that every suit shall be instituted in the court of lowest grade competent to try it. However, a decree passed by a court of a higher grade is not without jurisdiction and will only constitute an irregularity. As regards territorial jurisdiction, a suit relating to immovable property is to be filed in the court within the jurisdiction of which the property is situated, as given in sections 16 to 18. Suits relating to movable property and compensation for civil wrong can either be filed where the wrong is committed or where the defendant resides, carries on business, or personally works for gain, as given in section 19. Other suits can be filed at the plaintiff's option, either where the cause of action arises or where the defendant resides or carries on business or personally works for gain, as given in section 20. Sections 26 to 35b and orders 1 to 20 deal with the procedure relating to suits. The term suit has not been defined in the CPC. It refers to any proceeding by one or more persons against one or more persons in a court of law wherein the former pursues a remedy afforded by law for the redress of any injury or enforcement of a right, whether at law or in equity. A civil suit is a civil proceeding between two opposing parties, known as the plaintiff and defendant. There are 4 essentials of a suit. 1. Opposing parties. 2. Subject matter in dispute. 3. Cause of action. And 4. Relief. It is the plaintiff who institutes a suit by approaching the court and filing a suit for one or more reliefs against the defendant claimed in a pleading known as a plaint. This is the first stage in a suit. This is responded to by the defendant in his pleading known as a written statement. This is the second stage in a suit. Section 10 embodies the doctrine of res sub judice and deals with the stay of civil suits. It prohibits a court from proceeding with the trial of any suit in which the matter in issue is directly and substantially in issue in a suit pending between the same parties before a court which is competent to grant the relief claimed. The object is to prevent courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon 2 parallel litigations in respect of the same cause of action, subject matter, and relief. The second court, however, retains the powers to examine merits of the matter and pass interim orders. Section 11 embodies the public policy doctrine of res judicata, which lends finality to judicial decisions by preventing decisions which have attained finality in past litigation from being agitated again in subsequent litigation between the same parties. The provision can be broken down into the following elements, which are also preconditions for the application of the doctrine. First, the matter directly and substantially in issue in the subsequent litigation, whether on a question of fact or of law, must be the same matter which was directly and substantially in issue in the prior litigation, either actually or constructively. Second, the prior litigation must have been between the same parties or between parties under whom they or any of them claim. Third, the parties must have been litigating under the same title in the prior litigation. Fourth, the court which decided the prior litigation must be a court competent to try the subsequent litigation or the suit in which the matter is subsequently raised. Fifth, the matter directly and substantially in issue in the subsequent litigation must have been heard and finally decided by the court in the prior suit. And sixth, the decision of the court in the prior suit must have attained finality either because no appeal was preferred or the appeal was dismissed or no appeal lies. Constructive res judicata prohibits a party from taking a plea which he could have taken but did not take against the same party in an earlier proceeding with reference to the same subject matter. Similarly, any relief claimed in the plaint which is not expressly granted by the court shall for the purposes of Section 11 be deemed to have been refused. Order 2, Rule 1 provides that as far as practicable, a suit should be framed in a manner such that all matters in dispute between the parties should be disposed of finally. In each case, the court will have to see whether it was practicable for the plaintiff to frame his suit so as to include a cause of action which he had omitted or intentionally relinquished. Order 2, Rule 2 lays down that every suit must include the whole of the claim to which the plaintiff is entitled in respect of the cause of action. Where the plaintiff omits to sue for or intentionally relinquishes any portion of his claim, he shall not afterwards be allowed to sue in respect of this portion. This is based on the cardinal principle of law that a defendant should not be vexed twice for the same cause. It is designed to counteract 2 evils: 1. Splitting up of claims, and 2. Splitting up of remedies. The rule requires the unity of all claims based on the same cause of action in one suit. It does not contemplate unity of distinct and separate causes of action and applies only where the plaintiff is entitled to more than one relief in respect of the same cause of action. We will now proceed to examine a representative suit. A representative suit is dealt with in Order 1, Rule 8. It is a suit filed by or against one or more persons on behalf of themselves and others having the same interest in the suit. The following conditions must be cumulatively satisfied. 1. There must be numerous parties. 2. The parties must have the same interest in the suit. In other words, community of interest. The common interest need not arise from the same cause of action or transaction. Permission must have been granted or direction must have been given by the court. This is the next important condition. The permission can be expressed or implied and may be deduced from the proceedings. Fourth, notice of the suit must be given by the court to all persons interested. Since any decree passed by the court will only bind parties on record, the notice provides sufficient information to all interested persons, enabling them to apply to be impleaded. This provision is an enabling provision and does not compel any person to represent a community of persons having the same interest if his action is otherwise maintainable without joining the rest in the suit. Explanation 6 to Section 11 embodies an aspect of constructive res judicata. It provides that a decree passed in a representative suit binds all persons so represented who are therefore constructively barred from re-agitating the matters directly and substantially in issue in the former suit. This is subject to the conditions of Order 1, Rule 8 being satisfied and the representative suit having been conducted bona fide and on behalf of all persons interested. We will now briefly look at a suit by indigent persons. Order 33 provides for filing of suits by indigent persons. It allows them to prosecute suits without payment of any court fees, provided the conditions stipulated are satisfied. As per Rule 1, a person is considered indigent if he does not have sufficient means to pay the court fees or where no such fees is prescribed. An application seeking permission to sue in forma pauperis needs to be presented to the court, and the suit commences from this moment. Upon an inquiry in which evidence and witnesses may be examined, permission may either be granted or rejected. When permission is granted, the application shall be deemed to be a plaint in the suit and shall proceed in the ordinary manner. However, the grant of permission may be revoked in certain cases, such as when the plaintiff is guilty of vexatious or improper conduct in the course of the suit, when his means are such that he ought not to continue to sue as an indigent person, or when he has entered into an agreement under which another person has obtained an interest in the subject matter of the suit. When permission is denied, the applicant is granted time to pay the court fees. We will now proceed to study pleadings, which is a very important step in the civil court process. Order 6 deals with pleadings in general. The object of the plaint and written statement is to inform the opposite party of the case to be met, and they are used to ascertain the real dispute between the parties and outline definite issues by narrowing the area of conflict. The fundamental principles of pleadings applicable to both plaints and written statements are: 1. Pleadings should state facts and not law. 2. Facts stated should be material facts, that is, primary facts, also known as facta probanda, which must be proved at trial to establish the plaintiff's cause of action or the defendant's defense. Failure to plead any such fact denies the party the opportunity to lead evidence of that fact at trial. 3. Pleadings should not state evidence, that is facta probantia. And 4. Facts should be stated in a concise form, in other words, with specificity and certainty. It has been uniformly held that pleadings should be interpreted liberally and construed as a whole with attention to the substance of the matter rather than the form. Order 7 enumerates the rules in relation to a plaint. Rules 1 to 8 stipulate the particulars which every plaint must contain. An indispensable particular is a cause of action without which a plaint will be rejected. This expression has not been defined in the CPC and can be described as a bundle of essential facts which is necessary for the plaintiff to prove in order to succeed in his suit, or which give the plaintiff the right to seek relief against the defendant. It essentially constitutes the foundation of a suit. The plaint must also contain a statement of the value of the subject matter of the suit for the purpose of jurisdiction and court fees. The court fees payable is determined according to the Court Fees Act 1870 at the time of presentation of the plaint. It is essential for the plaint to have been filed within the limitation period from the date on which the cause of action arose. The limitation period is governed by the Limitation Act 1963. Where the suit is barred by limitation, the plaintiff must show the ground upon which exemption from the law of limitation is claimed. The general rule laid down in Section 3 of the Limitation Act is that every suit filed after the period of limitation shall be dismissed, and the statute does not contain any provision for condonation of delay in filing a suit. Every plaint must specifically state the relief claimed by the plaintiff, either simply or in the alternative. Where the relief is founded on separate and distinct grounds, they should be stated. The plaintiff is entitled to claim more than one relief in respect of the same cause of action. However, if he omits to sue for any particular relief, he cannot subsequently sue for the relief omitted except with leave of the court. The basic rule is that rights of parties should be determined on basis of the date of filing the suit. However, this rule can be departed from when the court is satisfied that in light of changed circumstances from the date of institution of the suit, the original relief is required to be molded or replaced by a new relief altogether. Sections 27 to 29, read with Order 5, discuss the issuing of summons, the process by which the defendant is notified of the suit filed against him and that his presence in court is required to defend the same. Order 5 discusses the various modes of service of summons, such as personal or direct service, service by court, service by the plaintiff, or substituted service. Order 8 enumerates the rules in relation to a written statement, which must be filed by the defendant within 30 days from the service of summons, which can be extended up to 90 days. The defendant is required to address every material fact alleged by the plaintiff in the plaint, state any new facts in his favor, and take legal objections against any claim of the plaintiff. A denial of any allegation of fact in the plaint must be specific and not vague or evasive. Every fact, if not denied specifically or by necessary implication, or stated to be not admitted in the written statement, shall be taken to be admitted by the defendant. Now we will proceed to examine issues. Order 10 deals with the first hearing, where essentially the court records admissions and denials of both parties. It is on this day when the court applies its mind to the case, either for taking evidence or framing issues. The framing and settlement of issues is the third important stage in a suit and is explained in Order 14. An issue arises when a material proposition of law or fact is affirmed by one party and denied by the other. Issues can be said to be of three types: issues of fact, issues of law, and mixed issues of law and fact. The court may dispose a case or any part thereof on an issue of law only if the issue relates to the jurisdiction of the court or any prevailing legal bar to the suit. It is imperative for the court to apply its mind and comprehend facts before framing issues. This is because it is the issues framed and not the pleadings which guide parties in adducing evidence. Therefore, the issues have a critical bearing on trial and decision. The court must decide every point on which an issue is framed, even if it is not mentioned in the pleadings. Allegations made on oath by the parties, allegations made in the pleadings or in answers to interrogatories, and documents produced by the parties may be relied upon to frame issues. The court may take assistance of the parties as well as examine witnesses or inspect documents to frame, amend, add, or remove issues. Omission to frame an issue constitutes a material irregularity only when it affects the disposal of the suit on merits. After the pleadings have been submitted in court, it may appear to either party that the nature of the opposite party's case is not sufficiently disclosed in his pleading. A party is entitled to know beforehand all material facts constituting the case of the opposite party and all documents in his possession or power relevant to the suit. For this purpose, the CPC provides for the following procedures after the settlement of issues. The first such procedure is discovery and inspection of facts and documents given in Order 11. After the settlement of issues, a party to a suit may require information from his adversary as to facts or as to documents in possession or power of such party relevant to the issue in the suit. Where information as to facts is required, a party is allowed to put a series of questions to his adversary known as interrogatories. The second procedure is admissions given in Order 12. Section 58 of the Indian Evidence Act declares that facts admitted need not be proved. Admissions may be made before or after the filing of the suit, and the judgment and decree may be passed on such admissions. The third procedure is production, impounding, and return of documents given in Order 13. The plaintiff must produce in court with the plaint the documents on which he is suing the defendant and a list of documents in support of his claim. A summons to a defendant should contain a direction asking him to produce all the documents in his possession or power upon which he intends to rely in support of his claim. Parties must produce their documentary evidence on or before the settlement of issues. Documents not admitted in evidence shall be returned to the person producing them. The court may, after recording reasons, reject at any stage of the suit any document which it considers irrelevant or inadmissible. The court may also, for sufficient cause, direct any document, book, or exhibit produced before it to be impounded and kept in the custody of an officer of the court for such period and subject to such conditions as it thinks fit. The fourth procedure is affidavits, given in Order 19. An affidavit is a declaration of facts only, made in writing and sworn before a person having authority to administer an oath. It should be confined to such facts as the deponent is able to prove to his personal knowledge except on interlocutory applications on which statements of belief may be admitted. The court may make an order requiring any particular fact to be proved by affidavit, subject to the right of the opposite party to cross-examine the deponent. The next important step in the civil court process is that of trial. After issues are framed, parties are in a position to know the facts and documents they need to prove. For this purpose, they may apply to the court to summon persons as witnesses. Sections 30 to 32 and Orders 16 to 18 contain necessary provisions for summoning, attending, and examination of witnesses. Since the plaintiff has the right to prove his claim, he has the right to begin in the hearing unless the defendant admits facts alleged by the plaintiff or contends that either on point of law or on some additional facts alleged by him, the plaintiff is not entitled to any relief, in which case the defendant has the right to begin. The party having the right to begin produces his evidence in support of issues he is bound to prove. The other party then states his case and adduces his evidence, if any, and addresses the court generally on the whole case. The party beginning may then reply generally on the whole case. Oral evidence may be recorded by the court commissioner in the form of an affidavit under Order 19, subject to the right of the opposite party to cross-examine the deponent. As a general rule, once hearing commences, it will be continued till final disposal. However, the court has the discretionary power to grant an adjournment upon the application of a party under Order 17. The next step is that of the decision itself. First, we will look at a judgment. Section 2, subclause 9 defines judgment as the statement given by a judge of the grounds of a decree or order. Rules 1 to 5 of Order 20 deal with judgments. It contemplates a stage prior to the passing of a decree or order. The court shall pronounce the judgment in open court either as soon as the hearing has been completed or within 30 days from the conclusion of hearing, the period extendable to 60 days on account of exceptional or extraordinary circumstances. The pronouncement of a judgment is essential for its validity. An essential element of a judgment is that there should be a statement for the grounds of the decision. Every judgment, other than that of a court of small causes, should contain a concise statement of the case, the points for determination, the decision thereon, and the reasons for such decision. Where issues have been framed, the court must record its finding with reasons on each individual issue, unless the finding upon any one or more of the issues is sufficient to decide the suit. The last paragraph of the judgment is required to precisely state the relief granted. The adjudications of a civil court may be divided into decrees and orders. Section 2, subclause 2 defines decree as the formal expression of an adjudication which conclusively determines the rights of parties with regard to all or any of the matters in controversy in the suit, as far as the court expressing it is concerned. The conditions to be fulfilled are that 1. There must have been an adjudication in a suit, and 2. The adjudication must conclusively determine the rights of the parties with regard to all or any of the matters in controversy, and 3. There must be a formal expression of such adjudication. The CPC requires a decree to be passed in all suits. Therefore, it is an indispensable requisite. An appeal lies against a decree, not a judgment. Rules 6 to 19 of Order 20 deal with decrees. The decree follows and agrees with the judgment and must be drawn up within 15 days of the pronouncement of the judgment. It can only be passed in a suit which commenced by presentation of a plaint. The party in whose favor a decree is passed is known as a decree holder, and the opposite party is known as the judgment debtor. Further, every decree is appealable unless otherwise expressly provided. Decrees can be of 3 classes. 1. Preliminary. In this decree, the adjudication does not completely dispose of the suit. In other words, the decree is only a stage in working out the rights of the parties which are to be finally adjudicated by a final decree. The second class is a final decree. A decree may attain finality when no appeal is filed against the decree within the prescribed period, or the matter has been decided by the decree of the highest court, or the court passing the decree completely disposes of the suit. The third class of a decree is a partly preliminary and partly final decree. For example, in a suit for possession of immovable property with mean profits, the final decree is the decree for possession of property, and the preliminary decree is the direction to conduct an inquiry into the mean profits. This is because the final decree for mean profits can be drawn only after inquiry and the amount due is ascertained. Therefore, even though only one decree is passed, it is partly preliminary and partly final. The CPC has also deemed certain adjudications as decrees despite not fulfilling the aforesaid criteria by way of legal fiction. These are known as deemed decrees. For example, Section 2, subclause 2 deems the rejection of a plaint and determination of any question under Section 144 as decrees. Section 2, subclause 14 defines order as a formal expression of any decision of a civil court which is not a decree. As a general rule, an order is found on objective considerations and must contain a discussion of the question at issue and the underlying reasons. Unlike a decree, an order may originate from a suit commenced by presentation of a plaint or from a proceeding commenced by a petition or application. In addition, an order may or may not finally determine rights and is appealable only if specified to this effect in the CPC. The next step in the civil court process is that of appeals. Unlike the right to file a suit, which is an inherent right, the right to appeal requires the sanction of law. Sections 96 to 112 and Orders 41 to 45 deal with appeals. An appeal is a continuation of the suit. An appellate court has the power to determine a case finally, remand a case, frame issues and refer them for trial, and to take additional evidence or require such evidence to be taken. Sections 96 to 99A, read with Order 41, deal with first appeals. Section 96, subclause 1, confers the right of first appeal against every decree passed by any court exercising original jurisdiction, unless otherwise expressly provided by the CPC. A first appeal is maintainable on a question of fact or of law, or a mixed question of fact or law. The appellate court may or may not be a high court. Although the provision does not specify locus standi, 2 conditions must be satisfied to file an appeal. 1. the subject matter of appeal must be a decree, and 2, the appellant must be an aggrieved person. In other words, the decree must genuinely and adversely affect his interests, pecuniary or otherwise. As per Article 124 of the Limitation Act, an appeal against a decree or order can be filed in a High Court within 90 days and in any other court within 30 days from the date of the decree or order appealed against. Any appeal filed after expiration of the limitation period needs to be accompanied by an application for condonation of delay, explaining that the appellant has sufficient cause for not preferring the appeal within time. When the trial court has decided the suit on a preliminary point and the appellate court has reversed the decree, the latter may remand the case to the trial court to adjudicate the other issues, excluding matters, if any, decided by the appellate court. Sections 100 to 103, 107 to 108, read with Order 42, deal with second appeals. Section 100 subclause 1 provides that a second appeal lies against a decree passed by the first appellate court and can only be filed in a high court on a substantial question of law. As per Article 116 of the Limitation Act, the second appeal needs to be filed within 90 days from the date of the decree appealed against. The substantial question of law needs to be such as between the parties in the case, as distinguished from a question of general importance. The appellant needs to precisely state the question in the memorandum of appeal. If the High Court is satisfied, it shall formulate the question and hear the appeal on the question. The respondent, who is the defendant in the original suit, can argue at the hearing of the appeal that the case does not involve the substantial question of law framed by the court. The High Court can hear the appeal on any other question not formulated if it is satisfied that the case involves such a question. Sections 104 to 106 and Order 43 deal with appeals from orders. Appeals can be filed only against those orders which have been made appealable by the CPC. The appeal lies to the court to which an appeal would lie from a decree in the suit in which the order was made. As per Article 116 of the Limitation Act, the appeal can be filed in a High Court within 90 days and in another court within 30 days from the date of the order. Sections 109 and 112, read with Order 45, provide for appeals to the Supreme Court when the High Court certifies that the case involves a substantial question of law of general importance and is of the opinion that the question needs to be decided by the Supreme Court. These provisions, however, need to be read with Articles 132 to 136 of the Constitution. We will now proceed to briefly examine the procedures of reference, review, and revision. Section 113 empowers a subordinate court to refer a pending suit, appeal, or proceeding before it in which the decree is not subject to an appeal to the High Court when it entertains a reasonable doubt on a question of law. Only a court can refer a case either on an application of a party or suo motu. Section 114, read with Order 47, empowers a court to review its judgment. This power can be exercised only upon an application by an aggrieved person. The power of review cannot be equated to appellate powers, and therefore the reviewing court cannot rehear the original case. A review petition is maintainable in cases where no appeal lies, an appeal lies but has not been preferred, and in decisions on reference from a court of small causes. An application for review can be presented as long as no appeal has been preferred. A review can be sought on any of the following grounds. 1. Discovery of new and important matter or evidence. 2. Mistake or error apparent on the face of record. And 3. Any other sufficient reason. Section 115 empowers the High Court to entertain a revision in any case decided by any subordinate court when it is satisfied that the latter has committed a jurisdictional error when no appeal, either first appeal or second appeal or appeal from an order, lies to the High Court or any subordinate court. Accordingly, the High Court is empowered to interfere upon an application or suo motu when the lower court has exercised a jurisdiction not vested in it by law, or has failed to exercise a vested jurisdiction, or has exercised its jurisdiction illegally or with material irregularity. This power is purely discretionary and can be used to only remedy jurisdictional errors. The High Court cannot interfere with any order passed by a subordinate court if it is within his jurisdiction, even if it is legally wrong. As per Article 131 of the Limitation Act, a revision application needs to be filed within 90 days from the date of the decree or order sought to be revised. The next step in the civil court process is execution. Execution is the enforcement of decrees and orders by judicial process to enable the decree holder to realize the fruits of the decree when the judgment debtor does not comply with the decree. It is extensively dealt with in sections 36 to 74, read with Order 21. Some important general principles governing execution are: 1. As a general rule, territorial jurisdiction is a condition precedent to a court executing a decree. 2. An executing court cannot go behind a decree and question or examine its legality or correctness, since an execution proceeding is collateral to the judgment. 3. An executing court can construe a decree whose terms are vague or ambiguous in order to ascertain its precise meaning. And 4. A decree which is a nullity on account of inherent lack of jurisdiction can be challenged in execution proceedings. The period of limitation for execution of a decree is 12 years from the date of the decree under Article 136 of the Limitation Act, except in case of a decree for mandatory injunction for which the limitation period is 3 years under Article 133. Section 51 permits the decree holder to elect the mode of execution from several options subject to conditions and limitations as may be prescribed by the CPC. The modes enumerated in the provision are: 1. Delivery of property; 2. Attachment and sale or sale without attachment of property; 3. Arrest and detention of judgment debtor in civil prison; 4. Appointment of receiver; and 5. Such other manner as the nature of relief granted may require. Section 47 lays down an important principle that matters relating to execution, discharge, or satisfaction of a decree arising between parties or their representatives should be determined in execution proceedings and not by a separate suit. It recognizes the exclusive jurisdiction of the executing court to determine all questions relating to adjudication. The object of the provision is to prevent unnecessary litigation and therefore must be construed liberally. Examples of questions covered by this provision are whether the decree is fully satisfied, whether the decree is executable, and whether execution of the decree was postponed. We will now proceed to examine the remedies. The focus of this lecture will be a very important remedy of injunctions. An injunction is a remedy in the form of an order of the court addressed to a party to the suit that either prohibits him from doing or continuing to do a particular act or orders him to carry out a certain act. Injunctions are preventive, prohibitive, or restrictive. In other words, when they prevent or restrain a party from doing something. They may also be mandatory. In other words, when they compel, command, or order a party to do something. An injunction can be ad interim, which is granted without finally deciding an application for injunction and operates till the final disposal of the application. Or an injunction can be interim, which is granted while deciding the main application and operates till the disposal of the suit. An injunction may either be permanent or temporary. This is another classification. A permanent or perpetual injunction restrains a party forever from doing the specified act and can only be granted on merits at the conclusion of the trial after hearing both parties. It is governed by sections 38 to 42 of the Specific Relief Act 1963. A temporary or interim injunction restrains a party temporarily from doing the specified act and can only be granted until the disposal of the suit or until further orders of the court. It is governed by Order 39 of the CPC and may be granted at any stage of the suit. The primary purpose of granting an interim relief is to preserve the property in dispute till the legal rights and conflicting claims of the parties before the court are adjudicated. Order 39, Rule 1 enumerates the grounds to grant a temporary injunction. The court retains the discretion to grant a temporary injunction which ought to be exercised reasonably, judiciously, and on sound legal principles. The three pillars upon which every temporary injunction order rests are: first, whether the plaintiff has a prima facie case; 2. Whether the plaintiff would suffer irreparable injury if his application for temporary injunction is not granted; and 3. Whether the balance of convenience is in favor of the plaintiff. The first pillar of the prima facie case. The court must be satisfied that the applicant has raised a bona fide dispute, that there is an arguable case for trial which needs investigation and a decision on merits, and that on the facts before the court, there is a probability of the applicant being entitled to the relief claimed by him. While determining whether a prima facie case has been made out, the relevant consideration is whether on the evidence led, it is possible to arrive at the conclusion in question, and not whether that is the only conclusion which could be arrived at on that evidence. The court should not examine the merits of the case at this stage because it is not expected to decide the suit finally. The second pillar of irreparable injury. Here the applicant must satisfy the court that he will suffer irreparable injury if the injunction is not granted, and that there is no other remedy open to him by which he can protect himself from the consequences of the apprehended injury. The expression irreparable injury, however, does not mean that there should be no possibility of repairing the injury. It only means that the injury must be a material one. In other words, which cannot be adequately compensated by damages. The principle has been explained in the landmark judgment of American Cyanamide Company versus Ethicon Limited. The third pillar, balance of convenience. Here the court must be satisfied that the balance of convenience is in favor of the applicant. In other words, that the comparative mischief, hardship, or inconvenience which is likely to be caused to the applicant by refusing the injunction will be greater than that which is likely to be caused to the opposite party by granting it. Examples of some other remedies which can be sought in the civil process are recovery of money, payment of compensation, specific performance of contract, declaration of title or possession to the suit property, partition of suit property, restitution of conjugal rights, attachment or sale of property, and permanent injunction, as said before. The last step we will examine in the civil court process is that of inherent powers. Inherent powers are complementary to the powers specifically conferred on the court by the CPC, which are exercised ex debitio justitiae by the court to meet the ends of justice or to prevent abuse of process of the court. This is because the provisions of the statute are not exhaustive, and inherent powers are required to address unforeseen circumstances. These powers are dealt with in sections 148 to 153b and provide for grant and enlargement of time, making up any deficiency of court fees, amendments in judgments, decrees, and orders, transfer of business, and preventing abuse of process of court. Inherent powers can only be exercised in the absence of express provisions in the CPC and in conformity with its express provisions and intentions of the legislature. The court must not misuse them to transgress or violate the CPC in any manner. They must be resorted to only in exceptional circumstances. Section 151 is a salutary provision preserving the inherent powers to meet the ends of justice and prevent abuse of process of court. Such abuse may be committed by the court or by a party. Accordingly, this provision has been used by the court to recall its orders and rectify errors, set aside illegal orders or orders passed without jurisdiction, revive execution applications, allow amendment of pleadings, take notice of subsequent events, among many other purposes.